Okay, so I'll just start with a quick update. Thank you very much for having me this morning. I'm really sorry I couldn't make it in person. Mo just had shoulder surgery 3 days ago, so he's been keeping me up, and it's been a really tough 3 days because he's been suffering quite a bit. So I have to stick around to do the morning routine with him. So thank you very much for inviting me. So just to give you a brief resume of what a security certificate is basically a tool under the Immigration Refugee Protection Act that allows the government to basically call you a threat to national security and arrest you without charge, without access to the evidence. So my husband was arrested on December the 10th, 2002, which also ironically happens to be International Human Rights Day. He was arrested, never charged, put in jail for 43 months. A year of that was spent in solitary confinement. After 41 months of detention, he was sent to a special facility that was open for just a security certificate detainees on the grounds of the Kingston Penitentiary. Basically, it was just two portable units that were welded together and had 6 cells in it because at the time there were 5 security certificate detainees and they were transferred there in secret. They were basically kidnapped from their cells, and the media and no one else has ever been able to see that facility. Now, that facility stayed open for 2.5 years after all the men were released on conditions. In May of 2006, my husband was released under conditions, which were the toughest bail conditions in Canadian history. I should mention that in 2006, we went to the Supreme Court, and the Supreme Court found that the security certificate was unconstitutional, that the person did not have enough evidence to defend themselves. So they gave the government 1 year to create a new law. And really, like, the government took exactly a year, like 5 minutes till the deadline, which was on a Friday at 5 o'clock. They reissued security certificate to all 5 men, and there's only 5 of them. And Mo got Hassan Amre's certificate, basically. The cover letter was addressed to Hassan Amre, and they were all reissued security certificates under the new law. The difference between the new law and the old law is that they added special advocates, which are based on the UK system, which are security cleared lawyers, which are allowed to see the secret evidence, but are not allowed to speak with the public counsel or the detainee once they've had access to that information. Basically, it's pretty useless. Special advocates have said from the beginning that their hands are tied behind their back and then that the process is totally unconstitutional. And Paul Cavaluzo, who was one of our advocates, admitted in a conference for the Mirar Arar 10-year anniversary that the reason why the government doesn't want to put the evidence public is because it is super embarrassing. He said that whatever they have in there is very embarrassing, and some of the information comes from or derives from torture. It is important to mention that all the original information that was collected on the certificate cases was destroyed. So all intercepts, interviews, notes that CSIS had was destroyed. So if you was in a criminal case and you destroyed one piece of evidence, the case wouldn't be able to go through in court. The case would fall apart. In our case, we have nothing original. All we have are transcripts of transcripts, and some of those transcripts were originally in other languages, and they're full of mistakes. And we all know that by the time it's like a telephone game, by the time you do the transcript the 5th time, it's not the same version as it was in the first. Second of all, we know that the conservative government gave CBSA and CSIS the green light to use information that comes from or derives from torture. That was a memo that was signed while the conservatives were in part with the leading party. And also our informant, who is the link to the majority, we would say the majority of the allegations against my husband, he failed his lie detector test, and CSIS failed to tell the judge. So we don't know. We will never be able to cross-examine the informant because under the new process, we thought that the special advocates were going to be given permission to cross-examine the informant in secret where no one would see his face or know his name. because we know that the informant in the Toronto 18 case, he's public and his life has never been threatened. He's actually made a career out of it. And I also heard that he's going to be leading that new department, the $35 million department that the Liberal government just created for preventing people to be recruited. So, I don't see the problem with having our informant being cross-examined in secret proceedings. So his credibility will never be tested. So that was a huge problem under the old law. We never got a fair trial. And from the beginning, we've always said, put the evidence out there so everybody can see it. All five men have never been afraid to defend themselves. They said, put it out there. We want all Canadians to see the evidence and we'll defend ourselves. And the major problem with our case is that the informant is someone that we're pretty sure that we know and that we'll never get access to, because the Supreme Court in their recent ruling decided to highly protect informants, because they said that basically if we reveal one informant, there's not anybody else that we want to come forward to help with other cases. So that has been a major problem. In 2006, when my husband was released on bail, we thought, yeah, it was so wonderful. He was detained for 43 months and we were waiting for it for so long. But it's the day that I literally became a full-time jailer and a prisoner in my own home. He had the toughest bail conditions, which included wearing a GPS bracelet around his ankle, and he wore that for 7.5 years. That thing never came off, and he had to plug it in a wall for 2 hours to recharge it every single day. We had surveillance cameras in our home. We had one in our living room and one in our entrance. Our phone was monitored. Our mail was open. All our visitors had to be pre-approved in advance. That would include my 80-year-old grandmother and my nephew that was born. We had to provide a picture of him as a newborn to get him pre-approved by the Canadian Border Service Agency to make sure he didn't have a criminal record and that he could come and visit our house. Every time somebody came to our house, we had to warn them ahead of time and we had to log in the information, and everybody had to be pre-approved. We wouldn't be able to allow anybody that hadn't been pre-approved in advance to enter our residence or be in contact with Mo. On top of that, we were allowed 3 outings of 4 hours maximum. So that would be a maximum of 12 hours out a week. Every location had to be pre-approved 48 to 96 hours in advance. That would include, for example, grocery stores, Tim Hortons. We couldn't deviate from any location that was approved that day, and we could not meet with anybody that was not pre-approved. On top of that, I had to watch him 24/7 inside the residence as well as on the property. He was not allowed to barbecue by himself in the backyard. For example, if we were barbecuing and he was running out of barbecue sauce, then he had to step in and I would step in. The government actually said one time it took me like 27 seconds later than he did, because we can't enter the doorway at the same time. It was really, really a pain in the butt. And plus he had a curfew on the property itself. He had boundaries within the city. All the routes that we were using on our pre-approved outing had to be pre-approved. And when we went out, the worst thing for me was being followed by CBSA officers wearing bulletproof vests and carrying weapons, sometimes 2, sometimes 4, sometimes 6, sometimes 8, depending on the outing. Because I'm short on time, I'll take some of the questions at the end, but I've got plenty of examples where we've had several outings where CBSA has sent between 2 to 4 vehicles to watch us do regular things like grocery shopping and attending a doctor's appointment. Like, per example, when you are on a pre-approved outing and you cannot leave Mo alone, what do you do with them? We had to sneak in public washrooms together. I had to go into men's washroom, and I had to, I prefer to try to, put him in a woman's washroom, but we had to share public washrooms together. And when I came to a doctor appointment, my doctor had to be pre-approved, and Mo would sit in a corner because he couldn't be left alone in the visitor room. So yes, ladies, I had my annual pap test with my husband sitting in a corner pretending to read a big medical magazine. So those years were super difficult. Many times he offered to go back to jail and I was out of the questions. After 3.5 years, the government mysteriously, suddenly decided to drop the majority of the conditions. The GPS remained in place. And also I have to mention that he's not allowed at the time he wasn't allowed to use a computer, and cell phones were not allowed in the house. So my computer would be under lock and key in the house. He would never be allowed in the room where I would have access to the computer. So after that happened, it changed quite a bit, because then I got some of my freedom back. I was able to, to go give talks, and he would be able to go around by himself, but he still had quite a bit of conditions left. This year, it will be 3 years since the GPS came off. And in a way, I'm very thankful that the GPS came off 3 years ago, because of the latest Supreme Court decision that was made in May of 2004. That would have been different. But in 3 summers ago, the GPS came off, and he was given permission to use the internet on a home computer, which is monitored by the Canadian Border Service Agency, and a cell phone, which we still haven't gotten, because the list of conditions regarding the cell phone are absurd. They're too long, and the phone would be monitored, and to us, it would be the equivalent of having a GPS in your hand. So basically, we haven't gotten a cell phone for that reason at this time. But his computer is monitored, and as you know, technology has advanced quite a bit. And during the time he was in jail, and for the years that he was under house arrest, he was not allowed to look at the internet. So he had no idea what his website would look like, what the internet was all about, because we didn't have internet at home before Mo got arrested. So he really didn't experience with it. Now he's a big fan of Kijiji, and he likes internet. He's actually on his computer right now as I'm talking to you, so he's enjoyed that quite a bit, but it is monitored. In the meantime, we went back to the Supreme Court twice. We went to the Supreme Court on the destruction of evidence, and the Supreme Court ruled that, yes, it was against the law to destroy evidence, and basically slapped CSIS's hand and said, don't do it again. And in 2014, we went back to Supreme Court because we wanted to fight the new process, which included special advocates, as unconstitutional. We also wanted to have access to the informant in secret proceedings. And we thought that it was unfair and illegal to have destroyed the original information, because we can't verify the voices for example, on wiretaps. We don't know who's speaking. We don't have anything, original transcripts. So there's no way for us to verify information whatsoever on that. Unfortunately, in May of 2014, the Supreme Court ruled that we did have enough information to defend themselves in public, although special advocates are not allowed to communicate with the detainee. So they ruled against us in every aspect of the case, because the Federal Court of Appeal had agreed that the certificate was unconstitutional and had quashed the certificate against Mo. So we were in a really good position. We were hoping the Supreme Court would at least give us a new trial, or give us an opening, perhaps have access to the informant, or eliminate everything that was destroyed originally as evidence, or evidence that came from torture, but they gave us nothing. It was a total shock and a real punch in the guts. We were devastated by the Supreme Court. We were really let down. I had really high hopes in the Supreme Court because we had been successful twice in the past. And so it's been a very difficult time since May of 2014. It was very quiet for 14 months. And then in the middle of the election campaign at the end of August, under the Harper government, Mo was issued his inadmissibility letter. So basically, the government ruled that the Canadians were facing more risk if he were to stay in Canada versus him facing torture if he were to return to Algeria. We all know that the political situation and climate in Algeria is not the best, especially after the war in the early 90s. And anybody going back there with terrorism allegations, which in my opinion are the worst allegations someone can have, to be returned to face torture, incognito prison, detention, without trial, without access to family, to doctor, to lawyers. And so he's at great risk if returned to Algeria. Just a few weeks ago, the government gave us more submissions, and those submissions confirmed that, yes, he does face torture if returned to Algeria, but the risk is Canadian if he stays here are much bigger. It's important to mention then that all of the risk assessment that CSIS and CBSA has done since 2009 say that Mo was not the threat he initially was when they first arrested him. And let's keep in mind, he's never been charged. My husband has no criminal record. He doesn't have any criminal record anywhere in the world. He actually passed his criminal background check just recently for a job that he applied for. Even before I passed my criminal background check, I had to get fingerprints done before I passed, and he passed his before mine. And so it's been very difficult because now we have a limited time for us to submit submissions regarding that. And we're also in the process of asking the Minister of Public Safety if we can get ministerial exemption, because he has the power to drop the case. Basically, we think that if the process goes along with the deportation, it would be illegal. It would be against the law. The last Supreme Court decision on deportation to torture said that you can deport someone under exceptional circumstances, but exceptional circumstances has not been defined. And we also signatory of several conventions against deportation to torture. And basically, my husband has had a huge cloud over his head for the past 13 years. We are in our 14th years. And every day we are living in fear that he could be deported back to Algeria. But we have fought since the beginning, and I refused. It is a subject that I haven't really discussed because I've kind of been I'm not saying in denial, but I've refused to discuss it because my husband is, in my opinion, as Canadian as anybody else that I know. He's been in this country for 20 years. He's paid his taxes, has had several jobs, has worked very hard, and deserves to stay in Canada with his family. And the right to have liberty and safety. And so we've been fighting very hard for him for the past 13 years. And we hope that all of you will support us in our fight against deportation to torture. And I think I'll leave it at that because I think I've reached my 10 minutes already. And I'm open to answering any questions, and I might have some funny stories to tell if we get some time there. But that's pretty much in a nutshell what a security certificate is. So basically, I forgot to mention it's only refugees and immigrants and non-status that are detained under security certificates. But Bill C51 is based on the same thing. So basically, Bill C51 is the Canadian version of what security certificates are. And for the past 13 years, we've been warning Canadians that they would create a law that would affect Canadians. So we need to act upon, if the C51 is under review, we all need to take a stand against it.